Okay, see if we have some others joining us. My name is Elizabeth Brown. I'm the Program Director for the International Board of Safety Professionals. And for our time together today, I want to go ahead and be aware of everyone's time and use our time wisely to begin presenting on our introduction to OSHA presentation. Then we will also have some slides on fire safety for this presentation today. Let's see. Okay. Just to introduce you as a brief introduction to the Occupational Safety and Health Administration. It is an agency under the United States Department of Labor, and it has established the health and safety standards that are seen as law in the United States, or any company that operates in the United States, that must be complied with. The law must be held as the standards for worker safety and health protection that companies and the people that represent the companies must comply with, or they are going against the law and can face fines and penalties. And we'll see that information here in a bit. Okay, OSHA's location. So it is a federal agency that we have throughout the United States. Their main address, you can see here on the slide, is found within the U.S. Department of Labor, and they are found in Washington, D.C. at 200 Constitution Avenue in the Francis Perkins building. Another way to access information for OSHA is through their website, which is just the acronym of OSHA and .gov, G-O-V. There is quite a bit of information. If you've not found their website before, there's quite a bit of information to provide you with plenty of safety and health guidance. They do list all of their current guidelines, as well as the regulations can be found there. Another helpful tool that I have found using OSHA's website is their access to their letters of interpretation. And so if an individual or a company has a question about a specific OSHA standard, they can write a letter to OSHA asking for interpretation and further guidance. And if a representative from OSHA answers that letter, then they send that to the person requesting the information, as well as they post that on their website. And OSHA enforces those letters, honestly, and wants everyone to not just know their standards and the regulations, but if there is a letter of interpretation posted on their website, they expect that the company and the managers are following that letter of interpretation as well. I'll continue talking about letters of interpretation and times that I've experienced how OSHA may have interpreted a standard throughout any course that I teach. So maybe some more today, as well as in our course for our Certified Safety and Health Manager that we'll be having upcoming. I've been a consultant in safety and health as an engineer for the past 15 years, and I have been involved in many OSHA inspections where OSHA has come on site to a client, and I've been a part of their investigation, their inspection. I've also represented companies when they've had a worker injury where we had to report that to OSHA. I've also had been involved in responding to rapid response investigations that I'll touch on briefly as well. So throughout this, I hope to provide you insight into experiences that I've had and how OSHA interpreted certain standards, so to help you further increase your safety in your workplace. And I keep mentioning OSHA's standard interpretation because OSHA has two different types of standards. I'll get to that in a minute after we talk about the history of OSHA, but the two different types of standards that they have are specification standards that, as they sound, are specific. They tell us specifically how do we comply with this standard in a workplace. They will give you exact dimensions, for example, for the height of a guardrail. But then we also have standards that need interpretation, like performance standards. And we'll talk more about that as we go along. Those standards just tell us kind of generally how to comply with with OSHA, but they don't tell us specifically how to. And that's where those letters of interpretation are helpful on OSHA's website. All right, so moving on. Some history of OSHA. So we have not always in the United States had federal-based standards that OSHA provides. It wasn't until 1971 that President Nixon signed, it was actually the end of 1970, that he signed the act that created the agency that we have now. And on the same day that he signed the act, and it was December 29th, 1970, he also signed the act that created the Environmental Protection Agency. So that was a big day in the United States for worker health and safety, as well as environmental protection. Prior to 1970s, we did have a Bureau of Labor Standards under the Department of Labor that was established in 1922. As industry grew in the United States and across the world, we also had a need for, this is where the need for safety and health standards came about. But between 1922 and 1971, there was also the growth of the union, so the workers' unions. And it was workers' unions that established and fought for worker safety and health protection in workplaces until OSHA was established in 1970. And you see here the reason for that is just continued economic and industrial expansion. The more we saw that, the more we saw increase in accident rates, and there was pressures to from those unions for Congress to pass the Occupational Safety and Health Administration and to create that agency. In 1972, additionally, the OSHA's training program was created that trained government and private sector private sector compliance officers to conduct investigations into complaints and other issues related to worker safety and health. Additionally, something that the long-standing program with OSHA since 1978 is the Susan Harwood Training Grant Program. A lot of companies that apply, or institutions really, that apply for these grant programs through the Susan B. Harwood program are typically universities, maybe other, large organizations, maybe like International Board of Safety Professionals that have identified a need for worker training in a specific area, and they apply for a grant through OSHA to be able to fund a team of experts to create that training program. Recent areas that I've seen these grants being awarded are for gaps that are seen in training, such as migrant worker training or temporary workers. These are kind of workers that tend to get overlooked in our workplaces because I can understand from a workplace standpoint that maybe I won't have, maybe this worker will only be with me for the harvesting a crop, or for maybe a teenager being hired over Christmas break just to work in a retail store. And so a lot of these workers are not getting trained because they're only going to be working for the company for a short period of time. But OSHA recognizes that these workers are still getting injured and still need to be provided with the correct and accurate workplace training so that they can perform their jobs safely. There's a statistic too that I'd like for you all to remember, that there's a very large percentage of workers that get injured and also fatalities occur on the first 3 days a worker is on a job. This is especially important to me to reinforce the need for workplace training at an onboarding or a orientation setting, rather than training occurring on the job, which is also important, but there's training that needs to occur for employees to know how to be safe prior to starting their job. And OSHA has very strict regulations about that. Lastly, with the history of OSHA, they started a voluntary protection program. We call it just an acronym, the VPP program, which I've had clients apply for. This allows employers to apply as model workplaces, and they achieve a special designation if they meet the certain requirements to show that they have very proactive safety and health management systems in place. They actually get a literal flag that can be flown outside of their workplace that says, we have been recognized by OSHA as an exemplary or a model workplace. And you might ask yourself, why in the world would somebody apply for this? Because you are literally inviting OSHA into your workplace to be evaluated. But it does offer some exemptions from OSHA inspections. Those types of inspections that are considered to be on a routine kind of basis rather than response to an injury that's been reported or a fatality. There would be some exemption for workplaces if they popped up, so to say, on a list to have an OSHA inspection based on an annual inspection priority that the regional offices might have. So there are some benefits also, depending on possibly a public relations or an employee relations benefit. Demonstrating that you are a model workplace takes commitment, strong, true commitment to workplace safety and health. And it could go a long way for customer relations, employee relations, to show that you have demonstrated this to OSHA and through this voluntary protection program. Okay, so we've talked about some history of OSHA and why it was created. Let's talk about what their mission is. And I'm sure, as you can imagine, based on their name, that their mission is to ensure workplace safety and health. They want to ensure the safe and healthful working conditions for all workers by setting and enforcing health and safety standards, and by providing training, outreach, education, and assistance to employers. They accomplish this mission through these actions that we have listed here. One of the things I feel like they put most of their efforts towards is developing and enforcing workplace safety and health standards. When OSHA was created back in 1971, we didn't wave a magic wand, as you would say, and magically, this big book of workplace safety and health standards was created. OSHA originally created the health and safety standards from our consensus standards that we have. If you're familiar with the National Fire Protection Agency, the NFPA is their acronym, and we'll talk about that organization shortly with our fire safety segment. But National Fire Protection Agency already had existing workplace safety and health standards for many things, like fire safety, handling of compressed gases, things like that. Also, arc flash safety with electrical hazards. So all types of things the NFPA had standards for, as well as ANSI, the American National Standard Institute, ANSI standards. So these existing consensus standards that still exist is where OSHA gets and still continues to use as the gold standard of pulling into their regulations. OSHA also says that they provide training programs and employer education. There are training programs on their website. OSHA does not pay OSHA instructors to go out into workplaces and provide training. I have gone personally, I'm an OSHA authorized instructor, but I do not work for OSHA. I've never worked for OSHA. A lot of people think I have, and they call me the OSHA lady, but it's kind of misconception. I am an authorized instructor, meaning I have gone to a training course offered by OSHA and been approved by them to teach courses, but they do not pay me to do it. I have to, find opportunities to provide these trainings. So to me, that's kind of a misnomer in a way, or that they say that they provide training programs. I think the main thing they spend a lot of time on is, developing those workplace safety and health standards, and then also enforcing those standards through targeted inspections. They also facilitate worker complaints, which they maintain as confidential if a worker requests for it to be confidential. On the complaint form that OSHA has, there is a box, and there's an online form and a paper form. And on that form, there's a box for the worker to check that they want their name to be to remain confidential, and not or to let the employer be aware of their name. I have been involved in many OSHA inspections, whether it be a phone call as a follow-up or an actual on-site inspection that came from worker complaints. And I've never had a worker say, yes, please tell the employer my name. So most workers choose to make their complaints confidential because they don't want to have negative repercussions. But OSHA does recognize that most of the complaints that are made come from disgruntled or ex-employees of the company. So they are not necessarily, against the employer. They just want to make sure that there's a safe workplace. And if there is a complaint that alleges or says that there's a lot of bad things happening in this workplace, they will have an unannounced, so surprise investigation on site to see for themselves if the complaint is true or not. They also would investigate any fatalities, catastrophes, or any serious accident. Now there's been a change to the injury and illness record keeping rule that says that we have to call OSHA and report a fatality within 8 hours of it occurring, a catastrophe also within 8 hours. And a catastrophe is defined as 3 or more workers are admitted to the hospital due to the same occurrence. Say a horrible explosion happens or a fire, and 3 or more people are not just taken to the emergency room or to the doctor for evaluation, but actually inpatient hospitalization, so have been admitted to the hospital. We also have a new rule that within 24 hours, if one employee gets admitted to the hospital for a workplace injury, we must call OSHA and report that within 24 hours. They also investigate complaints, like we just talked about. They offer on-site and virtual compliance assistance. And And with OSHA in our states in America that have that follow federal OSHA law. I live in a state where we follow federal OSHA law, and that's what we're talking about today. In my state, we have 2 regional offices. We have a regional office that's in our neighboring state that covers like 5 states. And then we have 2 offices in our state. So one is kind of central to our state and in the central area where there's a lot of industry. And then we have another office that's in the south portion of our state near a port. And so at those offices, there are compliance, safety, and health officers. That's what we call our OSHA inspectors. And there's probably about 25 inspectors in the entire state. There's also a person that serves as a compliance assistant or resource officer. So if a person, say a safety manager, has a question about an OSHA standard, they can call and ask that compliance resource or compliance assistance specialist for more information. Lastly, OSHA also mandates injury and illness reporting and record keeping requirements, and we'll see some more information on what those are in a few slides. All right, so major activities with OSHA. Again, we talked about most of this. I do want to point out, they set the safety and health standards for workplaces. They enforce those standards by when they conduct inspections. If they find any violations of those standards, then they will issue what we call citations and penalties for any violations. They also, again, provide training and resources on their website. And then they also provide training and authorize trainers like me to be able to go out into workplaces and train managers and employers and employees on these standards. We just talked about compliance assistance that they offer. They offer partnerships where they'll collaborate with organizations for safety initiatives. I've seen that in the construction industry happen positively, as well as through those Susan B. Harwood grants. They have experts and they rely on consensus standard experts to study hazards and develop best practices. Because, please remember that OSHA standards are law, and they don't change very often. They do change. They do change from time to time, but they have to be passed through our levels of having any new law enacted in the United States. So we had a significant change to the hazard communication standard about 10 years ago, and it's been recently updated since then. But when that occurred, where the United States adopted the United Nations standards for hazard communication, that process took 20 years. So politics can get involved and things can get involved. So oftentimes, especially when it comes to chemical safety and health exposures, there are better practices out there than the minimum requirements that OSHA might have. Another thing that OSHA takes very seriously that I've experienced is their whistleblower protection. And that means that there are safeguards and protections to employees that have reported unsafe conditions. I've had OSHA inspections, one in particular where OSHA was notified by an employee that they had been terminated, and they alleged that it was due to their reporting of unsafe conditions. So I represented my client in proving that that was not the case, that the worker had been terminated for other reasons. But they do take it very seriously. That is why they offer employees the confidentiality protection for when they make a complaint. So it's for any safety managers or employers on the call. I do strongly offer the guidance that never do anything that could possibly be considered as negative action against an employee that has brought an unsafe condition to your attention or has made a OSHA complaint, because that can be a very serious violation of the OSHA standards. Also, they also provide guidance for workplace emergency preparedness, which we'll talk about in our next set of slides with fire safety. Okay, so when we look at OSHA standards, we are going to look at them from, I always say, like wearing two hats. I don't have a hat to put on, but and especially as safety managers, we have to look at it both ways. One, as what are our employer responsibilities and rights under the OSHA standards? And then, because as a manager, I represent the company, I represent the employer, but I am also an employee, right? If I'm a manager within the company. So you have to know what are your employee rights and what are your employer responsibilities. So another thing to think about when we talk about OSHA standards, besides performance standards and specification standards, we have standards that we call general, that apply to everyone. Or general or horizontal, right? Like across the board, they apply to everyone. And those are things like hazard communication related to chemical hazards, worker training, that workers must be trained in the language and vocabulary they can understand. This is especially important if you have different groups of employees that predominantly speak different languages. You cannot just hand them a piece of paper with training information on it in English, for example, if they are not literate in English. That would not be correct or good training. The employer must keep accurate records of injury and illnesses, and we'll see what those forms look like and talk about that in a minute. And they also must perform tests in the workplace to monitor health hazards like air sampling to see is the air that the employees are breathing, is it in safe levels, or do we need to provide a ventilation system or possibly respirators in the interim. Another health hazard that we might experience that's very common in workplaces is noise. And so we have to monitor the workplace for noise levels, possibly provide employees with audiometric testing, so hearing tests, to make sure that their hearing isn't getting damaged. All right. Then we look at employee rights or worker rights. So, and then also these all go hand in hand with employer responsibilities. So, workers must be provided any personal protective equipment that the employer requires them to wear for work. The employer must provide that and pay for it for most types of personal protective equipment. There are some exceptions to that we'll cover when we get into the Certified Safety and Health Manager slides. They must provide hearing exams, those audiometric exams, or any other medical tests like blood tests for lead exposure is another example, to ensure that just there's different health and chemical hazards that require that employees have health monitoring. If you have employees that work around maybe in a foundry, around foundry sand, or any other type of work that involves silica exposure, that has very strict health monitoring requirements with lung x-rays and things like that to ensure that workers are not being exposed to too much silica because they could experience silicosis. We also talked about notifying OSHA of any workplace fatality within 8 hours, and then all work-related inpatient hospitalization. Also add to that within the 24-hour requirement, if you have an employee that experiences an amputation, and that could literally just be the very tip of the finger without bone loss. If a doctor writes on their records that there has been an amputation, that also has to be reported within 24 hours. The last thing that has to be reported within 24 hours is the loss of an eye. I'm very thankful I've never had to experience that myself or to have a worker experience it. It seems somewhat rare, but amputations, unfortunately, are somewhat common in workplaces, and there's been a lot of amputations reported to OSHA since they made this requirement. If you do have an OSHA inspection in your workplace and you receive a citation and penalty, that citation must be posted within the workplace for any employees to see, as well as we have an annual summary of the injury and illness data where workers can see those. So, a break room or somewhere that prominently displays that is appropriate. You're also required to have the official OSHA job safety and health poster. You can find that on OSHA.gov and simply print it out. Or there are some posters that have things like what the federal minimum wage is. It's got a lot of like employee type of federally required posters within this big poster, and it only has that on there. But if you do not have that posted in your workplace, please go to OSHA.gov and you can copy that wording down there. You could just say OSHA poster in the search, and you should be able to find that and print it out. We must also offer workers whistleblower protection. So make sure we're not retaliating or discriminating against workers for exercising their rights under the law, which includes reporting injuries and illness, making a complaint to OSHA, or reporting unsafe acts or conditions. Okay, so again, worker rights. Workers must be provided working conditions that do not pose a risk of serious harm. I would say we want our workers to go home in the same condition that they came to work. That's the main goal. They have the right to file a complaint with OSHA and to have their workplace inspected. They have a right to receive information and training about hazards, ways to prevent harm from the hazards, and about the OSHA standards that apply to their workplace. That was a point I was going to make too, is there are a lot of OSHA standards out there that might be considered, instead of horizontal and apply to everyone, they're vertical, and they may only apply to your specific workplace. But it is the employer's responsibility to know which standards apply to their workplace and which don't, and make sure they're complying with the ones that do apply. Training must be conducted in the language and vocabulary a worker can understand. We talked about that briefly. I have experienced in some areas workers that cannot read. So in that situation, the workers must have training conducted like we're doing right now, where someone reads it to them. And if there's any, a test or an assessment or a quiz, that must be read to them as well. Workers also have a right to receive copies of records of their own work-related injuries and illnesses. And then they do have the right to review the annual summary. In terms of their own, like if they say they were involved in an accident or they had a health hazard issue, those things would only be confidential for the worker themselves. But the overviews and the summaries, all workers have the right to review. If like I just mentioned that, if a worker is exposed, say they have a hearing test done or a chest x-ray for silica exposure, they have a right to receive copies of those results from the test, and just like you would any other doctor's protocol or your results from tests if you go to the doctor when it's not related to work. They also have right to receive copies of, to participate in an OSHA inspection. So typically, and we can talk about this more another day. But in an OSHA inspection, OSHA compliance, safety, and health officers will ask to do interviews with different employees. And during that time, if an employee is not chosen for an interview, they can request to speak to the inspector privately. But that is a routine thing that occurs in OSHA inspections, is that private interviews with the OSHA inspector. Employees have a right to file a complaint with OSHA if they've received retaliation or discrimination. So under that whistleblower protection, they have a right to also file a complaint with OSHA saying that they were fired. If they felt like they were fired for reporting an injury, that would be an example of reporting this to OSHA. The law, the requirement says that if an employee feels they've been discriminated against or punished for reporting an unsafe act or condition, they report that to OSHA. But for under OSHA standards, they only have 30 days to do so. You'll see the next bullet mentions that those OSHA whistleblower protections apply to 21 additional federal laws. They apply to laws that we have for financial institutions, for environmental protection, things that aren't just under worker safety and health. OSHA enforces those whistleblower protections. And each of those different laws have different requirements in terms of how many days an employee has to report that adverse action to OSHA. Okay, there are a lot of health and safety standards that OSHA has. They are split into 4 different categories. We have general industry, which applies to manufacturing, a lot of different types of organizations. We also have construction standards for any type of construction site. These can also apply to, say you work at a manufacturing facility and you're having construction completed, you're adding on to your building, or you're building a new facility. The construction standards would apply if that activity is considered construction. So there are times when different OSHA standards apply to your work. Outside of OSHA, we also have the Mining Safety and Health Administration that conducts these same types of health and safety standards and inspections on below ground mines and level mines, strip mines as well. So I've worked with many companies that work in the mining industry where they have to comply with the mining safety and health standards and OSHA standards. So we have general industry, construction, we have maritime standards that, like you can see here, 2004, the fire protection standards in shipyards was developed. So we have maritime standards that apply to different activities that occur over water. And then lastly, we have agriculture standards that are kind of the smallest standards. They don't have too many standards for agricultural operations. So we have some other things here that you can see, like hexavalent chromium exposure, respiratory protection equipment, electrical installation, and then, there was an update on a clarification for payment for the personal protective equipment. And we'll see that when we get into the PPE part. Okay, so we see there was also an update. When you see GHS, that stands for the Global Harmonization System. That was the update that we had. There was a significant update that went fully into effect in 2015 to the Hazard Communication Standard. And that's where OSHA fully incorporated the United Nations standard for hazard communication. You can see some updates to electric power generation occurred, transmission and distribution, as well as electrical protective equipment occurred in 2014. Another significant standard that got a lot of attention from my clients was the respirable crystalline silica exposure limit was significantly reduced, causing employers to have to put in a lot stronger protections in place for employees. As well as we had some updates to our general industry walking working surfaces and fall protection standards, where what you see is, for the most part, they incorporated what we had in place for the construction standards for fall protection. Okay, so in terms of OSHA and then enforcing the health and safety standards, OSHA conducts inspections of workplaces to assess compliance with the safety and health standards. There's a priority of inspection. The first thing that they would inspect is an imminently dangerous situation. So if an OSHA inspector is driving in their car and they see a worker on top of a roof without fall protection, for example, or a worker in a trench below ground without the proper shoring of that, they have a legal responsibility to stop and stop that work from happening, because it's imminently dangerous. So we're trying to prevent an accident or a death from occurring. The next priority of inspection is going to be a report of a fatality, or a catastrophe, or an inpatient hospitalization like we talked about. The third priority would be worker complaints or referrals from maybe other agencies. And then the last level of priority for inspection is these focused inspections that they might have. So they might focus for this year on things like programmed inspections. They might have a focus on a powered industrial truck or forklift safety. Or hexavalent chromium is a good example. I have a lot of clients that do a lot of heavy welding, creating truck bodies for trailers and garbage truck bodies. So there's a lot of welding fumes that workers are exposed to. So I've had OSHA inspections from these regional enforcement programs where they have this special focus on a specific hazard. So when they come in and conduct the inspections, inspections are unannounced. The OSHA inspector can actually receive penalty and jail time if they notify the company ahead of time that they're coming. So it is a surprise. They have the right to conduct a walk around or an inspection of the workplace. They can inspect your training records. They can inspect your injury and illness records, and they can inspect any written compliance documents that you have. So if they find that there are any infractions or that the company's not following the safety standards, then they can issue citations and penalties. And then they will also want you to issue a report demonstrating that you have corrected those safety hazards. They can and do follow-up inspections. I think it's about 5 to 10% of the workplaces. They will do follow-up inspections to verify that employers have addressed the issues that they found in their previous citation. The penalties themselves can range from $500 to $130,000 in US dollars. So they can be, or actually a little bit more than that now, I think $135,000. So they have different types of citations they issue. We have serious citations, other than serious citations, willful, which if it's an owner of a company is issued a willful citation, that means that they knowingly and willingly committed this safety violation with intention of breaking the law, with intention of putting this worker in harm's way. And so the owner of the company can be sentenced jail time because it's a criminal act at that point. Thankfully, I have never worked with anyone that, and I've not experienced many times where that's happened, but they certainly have and probably should have for workplaces that are intentionally putting workers in harm's way. You also can get a citation and penalty that's high, like that, like willful. It's called repeated. And so if OSHA does the follow-up inspection and they come on site and see that the things they identified in their previous inspection are still, that hazards still exist, then they can issue repeat violations that can be upwards of $135,000 per violation. And they also have a multiplier for that is based on the size of the company. So if it's a larger company, they can have like a 5 times multiplier. So each violation could result in over a $500,000, $500,000 US dollar fine. So that's a lot of money. There have been OSHA penalties that I've seen for large companies that were over $2 million. We do have an appeals process. So if an employer receives a citation and penalty, you can file to appeal that. OSHA asks that you consider doing what we call an informal settlement conference. And I've been involved and represented clients in many of those where we kind of make a case for whatever, maybe an accident occurred or that hazard occurred that was highly unlikely it would happen again. And we show that, we have a good safety program and here's how we fix this hazard and to make sure it won't happen again. A lot of times during that process, OSHA will reduce the penalty that the company receives. I've had them reduce them by 50%. The other appeals process is a formal appeal, and that goes through due process that we have in the United States, and can go up to a circuit court judge locally. In some cases have gone all the way up to the Supreme Court. Okay, so our record keeping requirements. So under OSHA's record keeping regulation, certain employers in high hazard industries and certain employers that have so many employees, they must maintain records. There's 3 different forms, but they have to maintain records about any injuries or illnesses we have in the workplace. So first, Form 301 is like an accident report, or it's called the Injury and Illness Incident Report. OSHA will allow that a company uses their own version as long as it has the same information as we find on Form 301. So we would complete that for any serious injury or illness that occurs that's work-related. And it's considered a serious injury or illness if an employee misses a day of work, goes to the doctor and receives medical care, like a prescription, an IV, they break a bone. We could probably spend another hour at least talking about all of the different things that make an injury or illness work-related, and also what makes it what we call a recordable injury. There are some exceptions. An employee can get hurt at work and receive first aid, over-the-counter pain medication. There's, again, a lot of different, it's kind of a decision model you have to follow to determine, is it considered an OSHA work-related illness and injury. So once we fill out that accident report, that's the first step, the Form 301. Then that injury gets listed on our, what we call our OSHA log, or you might have heard of that, or Form 300. And those have case numbers, and those get listed, and you track, was it an injury, an illness? Was it a fatality? Hopefully not. Did it involve days away from work? Did it involve a job transfer or restriction? And then what type of injury was it? So some basic information that we gather from the Form 301 goes on the Form 300. And then lastly, we have the Form 300A, which is our annual summary and even kind of higher level view of all of the injuries that occurred in the previous year. And that gets completed by January 31st, or has to be posted by February 1st through April 30th. So right now, companies should have the OSHA Form 300A posted for 2024 until April 30th. Okay, that is the end of this presentation about just the introduction to OSHA. I'm going to open it up to see if anyone has any questions. I'm afraid we will not have time to get started with the fire safety slides, so we will have to, I think, put that off until tomorrow. But I wanted to open up to see if anyone has any questions. If you want to raise your hand or turn your mic on to ask the questions, that would be great.